Sorry, don't worry about it.
So we have Richard Goldberg, and he's going to talk to you about, well, the stuff on the screen, basically legal and privacy issues in cloud computing. Let's all welcome him. Thank you.
Thanks. I don't have a great accent like the last guy. I am a lawyer. Anybody else a lawyer? Okay. When I talk to lawyers about cloud computing, I usually assume very little knowledge, but a great deal of arrogance. This one I'll assume a little bit of knowledge. I am a lawyer. I'm not your lawyer, except some of you, and you already know who you are. And also, I've been to ShmooCon before. I support the Shmoo Balls. Decide whether your idea is good enough to throw things at a lawyer, and then hurl away. Cloud computing is dangerous. This talk is not about the regular security issues, the attack vectors that you're used to. You can think of these as legal attack vectors, things you might not have thought of, your lawyers might not have thought of, but it's all in the legal realm. So we're not talking about all the various sorts of attacks you normally have in IT, because those are very similar in cloud. Cloud computing is a lot like flying instruments only. That's why I call the talk that. And the reason is that you're basically stuck with what the provider tells you. And if there's a crash or if there's some other problem, you can kiss your ass goodbye. So there are three questions I intend to answer. One is, what are the risks? The second is, are you protected? And the third is, what can you do? So what is cloud computing? It makes sense to ask for a definition of cloud computing, but for our purposes, it doesn't make sense to answer it because it turns out it doesn't really matter because the things that are sort of cloud and the things that are true cloud are all more or less the same. They have the same sorts of legal problems. This is really old problems that applied to a new medium. There are two things about cloud that make it dangerous. The first is multi-tenancy, having multiple customers in the same place, and the second is third-party possession of your data. And it's the combination of these two, or sometimes just one of them, that creates almost all of our problems. So why is cloud risky? Groucho Marx once said that man does not control his own fate, the women in his life do that for him. And that's sort of the problem. It's a control problem. But it's not just a control problem. It's also a problem of transparency. Now, for technical reasons, cloud proponents will tell you that what you're doing is you're trading in your control, and you get back transparency. And that's good insofar as it goes, but it doesn't go that far for legal problems. So last year, if you used Google Docs, you may have received this email. Dear Google Docs user, we've identified and fixed a bug which may have caused you to share some of your documents without your knowledge. That was written by a lawyer. At that time, Google Docs had about 4.4 million users, and they said that it affected about 0.05% of documents. Now, if you assume that every user had one document, and that's probably not that safe, you end up with 2,200 users, which doesn't seem like a lot if you're Google and have 4.4 million users. But if you're a small or medium-sized company, or if you're a company that has traditionally had problems keeping track of its documents, that's a lot of documents. On October 4th of 2009, there was a Sidekick problem. Now, Sidekick was run by a company called Danger. Microsoft had purchased Danger, which is weird because Microsoft usually sells Danger. But on October 4th, about 1 million customers lost their data. And while Microsoft and Danger and everybody went searching for the backups, it took 2 weeks for it to be restored. Now, part of that was the problem was that these devices would lose their data when they were reset. I don't know who thought that was a good idea. But it meant that the data, when it was restored, was 2 weeks old. And in the meantime, if you were using this for your business, you were sort of screwed. On October 19th of last year, there was a problem with Google Voice. Voicemail transcripts began showing up in Google search results. Now, Google apparently knew about this and went about trying to fix it, even though they said it wasn't a problem, but didn't tell anybody. There's an old saying, he who knows does not speak. They sort of meant Google, and maybe also Toyota if you've been reading the news. So maybe October is just a bad month. And maybe Google Voice isn't true cloud, or T-Mobile Sidekick wasn't true cloud. But the question is, when you're looking at this before the failure, how do you know? With a lack of transparency and with no control, you can't. Which means that cloud computing right now is a lot like bungee jumping, where you don't know the height of the bridge, or the length of the rope, or if the rope is made of rope, or if it's attached to anything but your ankles, and you don't know any of these things until after you jump, because you can't test it. So there are 4 things I want to talk about. The first are inherent dangers. These are the sort of direct dangers that are inherent in this sort of thing. They're things you might have been warned about, but you still may not see them coming. The second are service agreements. These are the cloud service provider agreements. What some of them say, they're all very similar. The third are collateral dangers. These are the things that you really probably didn't see coming. They're legal issues that come from the side, and you might never have known that they were there. And the fourth are solutions, if there are any. So inherent dangers. As I said, these are the things that you may be warned about, but even if you're warned about them, you still may end up in trouble. The first is federal data protection laws. There are some. They tend to apply to industries specifically. For instance, there's HIPAA, the Health Insurance Portability Accountability Act. This requires a few things. First, it requires what are called business associates agreements. These are agreements with your data providers, service providers, that basically apply HIPAA to them. Google Docs will not agree to this. The second is that you have to protect against reasonably anticipated threats or hazards. I don't know what's reasonably anticipated anymore, everything. And the third is if you don't have your data encrypted, the data breach reporting requirements are very onerous. Bobby Rush sponsored a bill in the House this year that passed in December called the Data Accountability and Trust Act. It had protections for identity theft that mirrored the banking industry's protections. It also required notification to consumers and the FTC unless there was a finding of no risk of harm. Now, unless they know what your data is, I don't know how they know. What's important to you, how they know what's no risk. Importantly, it preempts existing state law. It was only passed in the House, so it hasn't obviously gone into law yet because it has to be passed by the Senate and signed by the President, but it is a possibility. Now, Senator Leahy also introduced something called the Personal Data Privacy and Security Act. These things may end up getting melded. The idea was notice, again, and a few methods to prevent data breaches. Now, he's introduced this thing 3 times. I don't know if it'll ever pass. But it's not just the feds. The key data laws are in the states, and there are a lot of them. 45 states and D.C. have data breach laws. They're all different. Some are less strict. Utah requires a person who becomes aware of a breach to determine the likelihood that it has been or will be misused. I don't know how they know that, especially if it's my data. Some states are stronger. Massachusetts has a law that goes into effect very soon, requires encryption of transmitted records, requires encryption of stored records on portable devices. It, by law, will require operating system patches. The key to these is that they all tend to do 3 things. One is they require some level of security or other. They require notification on breach, and there's an added requirement for certain types of data, like health information, that they notify you. And they may have to notify the FTC or other entities. There are international data protection laws. The European Union has very strict laws. And in particular, the UK Data Protection Act does not allow data to be transferred outside of the country unless the country to which it's being sent has an adequate level of protection. This comes into effect in different ways. If you want to transfer email out of the UK, it requires employee consent, or the consent if it's not an employee. That consent has to be free, informed, and revocable, which means that you cannot tell an employee that unless you consent, you're fired. That's not enough. That's not free. I had this happen with a client who was in the U.S. The company stored email in the U.K., and the U.S. government showed up to the U.S. version and the U.S. company and said, "Hey, we'd like your email. Here's a subpoena." And they had to get her consent to get it back in the country. There are also corporate data policies. These will depend on the size of your corporation and how sophisticated it is. Some limit HR data from being transferred out. Some limit information provided for health or life insurance. Some for marital status or disability, or both. And some limit transfer of Social Security information. There is the PCI data standard. If you are subject to this and you give your data to a cloud provider that doesn't do the things that PCI requires, audits and that sort of thing, you could be liable for a ton of money. This is one you may not have thought of, but the attorney-client privilege is important if you are ever in danger of being sued or investigated by the government. The things you talk about with your lawyer are protected. Among the requirements, though, are that you take reasonable precautions with the data. If you give the data to 3 jokers who run a cloud company, I don't know that that's reasonable. Now, the final one I'll talk about is civil discovery. This is what happens when you get sued or you sue somebody. It's a period of discovery where you give over information to each other. And the federal rules require you to produce information in your possession, your control, if it's electronically stored in any medium, if it has to be translated, that's backup tapes if they're available, encrypted data that's available. The result of this is that if your data retention policies differ from your cloud provider's policies, your data may just be sitting around. So this is what a subpoena looks like if you've never seen one, if you're lucky enough never to have seen one. Zoom in. Commands you to produce all correspondence and or documents memorializing communications between you and any officer, manager, partner, member, or employee of Sucker regarding the idea you had and we stole. Sorry. We had and you stole. So on the cloud provider, have your files been deleted when you delete them? Are they sitting on a backup tape that you don't have access to? You may have to produce them. So second issue is cloud service provider agreements. These contain what you might think they contain. As Napoleon said, the best way to keep one's word is not to give it, and that's what they do. For instance, Google Docs. I just picked 2 that were easy. 4.2, you acknowledge that the form and nature of the services may change without prior notice. Sounds like they could just stop providing it. 4.3, you acknowledge that Google may stop providing the services to you without prior notice. So what happens to your data if they stop? 4.4, you acknowledge you may be prevented from accessing any files contained in your account. The idea behind cloud, one of them was you don't have to worry about IT infrastructure, you don't have to worry about backups, except that you have to worry about backups. And they're all pretty much the same. MobileMe, you might use this for your business. They reserve the right to stop the service at any time without prior notice. It's very similar, and they tell you you're responsible for backing up. The point is the cloud provider agreements tend to protect the cloud provider and not you. Third one, this is the most interesting, collateral dangers. These are the sorts of dangers that you're not really going to see or recognize until they wake you up at 7 in the morning wearing FBI windbreakers. Oscar Wilde once said, "To expect the unexpected shows a thoroughly modern intellect." He was upstaged by Donald Rumsfeld, who said there are also unknown unknowns, the things we don't know we don't know. And the poetry of Donald Rumsfeld applies to cloud computing. A third-party subpoena is a subpoena in a case where 2 parties, one is suing the other, and they want data from a third party. So they issue a subpoena. And that requires you may not be involved in this case at all, to produce documents that they ask for that are in your control. Now, if it's you, it's a big pain in the ass, and it's expensive. But imagine that 2 parties are suing each other, and you don't know them very well. Maybe you did business with them. Maybe you didn't. And they issue a subpoena to your cloud provider. There's no requirement that you be told about this. The provider agreements don't require it, which means that your provider may be giving up your sensitive data, and you never know. Why would he tell you? Third parties also want your data. There's nothing to prevent, very little to prevent, any third party who wants to contract with a cloud provider. Maybe they want to do searching Another company that may want to index your data is Google. They want all of your data. I imagine a conversation at Google when they first started indexing, when they said, we're going to get all the information in the world, we're going to put it all together, this big search engine, and people refer to it on the news. And somebody said, wait a second, a lot of data is stored on computers, personal computers, that we don't have access to. And so we said, no problem, we'll get them to send it to us. So you'd never know what they're doing with it. You don't know who they sell it to. You know if they aggregate it and sell it, if they sell it individually. And this is a problem of control and transparency. Search warrants. A Fourth Amendment search warrant requires probable cause. That is a standard that they can usually make. But there's something called the Stored Communications Act. And there's a 2703 order, 2703D order. The important part of that is that it requires what are called specific and articulable facts. The data is relevant or material. That's not that hard. Now, there's a prior notice requirement in the SCA. They have to tell you ahead of time if they're going to take your data, except that it can be postponed for 90 days. It's not really prior notice anymore. So this guy looks like a child pornographer. Can we just agree? He was. His name is Richard S. Goldberg. I will point out right now, I am Richard P. Goldberg. We are not related. So this guy was running around with us, doing child pornography, and he was on the run. He was on the FBI most wanted list for 6 years or something like that. He was captured. But imagine that he was using your cloud service provider. The FBI finds out, and they issue a search warrant. They go to every single data center, and they take everything. The problem is that, unlike certain investigations, child porn investigations involve contraband. FBI can't let these things out. They can't just say, "Oh, we'll just take a copy. Keep your child porn on your own." And so they will back up a truck and take everything. This could shut down your business. Something very similar happened in Texas, and I asked a friend of mine who's an assistant U.S. attorney, not in Texas but elsewhere, I won't tell you where, and I said, look, you have this, this hypothetical, there's a child porn ring, and you find out that they are storing this stuff in this cloud service provider. That there's no way to take this stuff without shutting down not just the cloud provider's business, not their fault, right? But because we don't want them looking at our data, but also every business that uses it. And they're not going to have any notice. It's just going to shut down like that. Would you do that? Seems to me they'd have to. And he was my friend went to the person in charge of the district, and he asked him directly the same question, and I got a very direct answer. I'm quoting. No comment. So what do you think they're going to do? So will your cloud provider agreement to help? Let's just look at one. They're kind of long and dense. You acknowledge they may disclose your content when it's necessary to comply with a legal request or to protect the rights of the public. It may just be gone. And the problem with this is that, it's sudden. And you have no notice of it, and it just kills you. Okay, so are there any solutions? Yes and no. First, you need to demand transparency. You need to know who's running the cloud provider and what they do. Google has been contracted by Los Angeles, and if you're Los Angeles, you can negotiate these things. Smaller companies, small organizations can't yet, but cloud computing is changing, and we'll get increased transparency. Just like everything, providers will have to start taking some amount of responsibility, though there's a question about how much. If you've ever gone skiing or rented any motorized device, you know that you sign away your life. And that hasn't changed. But I think for sophisticated businesses, it will change. You also need to demand control, and these are all just subjects of negotiation. So what are the details? Remember, the goals are control and transparency. So, first, you want advance notice if your data is going to be released. If there's a subpoena, They're not instant, and so you want to know ahead of time so you can contest it. Second, you want prompt notice of a breach. This includes if the FBI shows up. It includes if there is a breach and they don't know if your data was leaked. You still want to know so you can be on the lookout for it. You don't want them to say, well, it's probably fine, no risk of harm. We're not going to tell you. Third, the data is yours, it is not theirs, and they have no right to sell it. They can use it only to the extent that they need to use it to figure out if their service is working. It also means they shouldn't be able to hold it hostage if you don't pay them, or if they think you don't pay them. It should just be off the table. Fourth, you want a clear data retention policy. You want to know what they're doing with backups, what they're doing with deletions, how that stuff works. And you need to, if you can, get them to implement a policy that's at least as good as yours. Finally, you want some sort of audit rights. Now, there may be standards bodies that are created that will do independent audits, and you won't have to. But your company may want to do audits on its own. Mark Twain once said that, to paraphrase him, first God created idiots. That was for practice. And then he created standards bodies. But it may be useful. We don't know yet. But this does not solve all of our problems. For instance, they may just not notify you even though they're required to. That's no less a business risk, even though you could sue them for it. Right? Your data's still gone. Second, they may just not adhere to their policies. Even if you do audits, they may not adhere to them, because after all, you only do audits every so often. Third, there's just nothing you can do about a data seizure or failure except to diversify your risk. But that was the point of cloud computing in the first place. Right? These people were supposed to take this problem off your hands. They do backups, they do scaling. Problem is, they may screw up. Fourth, you don't know who's accessing your data. They have employees. They may have bad security. They may have employees that get angry when they get fired. It's not like nobody's ever been laid off and stolen data. And you don't know what will happen to it. You don't know what their procedures are for figuring out who's a good employee and who's not. And finally, they may still hold your data hostage. This happened to me once when I was running a website. I had an argument with a company, and they said, look, you either pay us extra or we're not going to give back your data. I said, screw off. But if your data is important to you, then you're screwed. So remember, the key issues are a lack of control and a lack of transparency. And to the extent that when you're in the cloud, you can fix that, you're in a lot better shape. Thank you. So I'll take questions if there are people watching and want to do it via Twitter. I'll pull my phone out. That's my Twitter name. Questions? Okay, you were first.
Yeah, I can see how some of this would be a weed by making sure you always encrypt to the cloud, decrypt from that. But we won't address everything. I was wondering what your feelings are about how much safer that makes the cloud
Well, if you're just storing data, then you could encrypt it before you send it, right? If you're using it for software as a service, for instance, it can be encrypted there, and it can be encrypted when it's transmitted, but those are not the same encryption, right? And so it's going to have some processing time where it's available. So it's dangerous there. But if it's stored encrypted and you hold the key, you're much better off. If the provider offers encryption, which you think they should, then they hold the key. So the question is, where's the key, right? If their employees have access to the key, they may store it on a Post-it note. Well, not key, but they can store it somewhere where people can get to it. And so it's better, but it's good if somebody loses a laptop, although I don't know why your data would be on a laptop when you're having a cloud provider, but they do weird things, and you still have the same problem. So yeah, encryption's better, but you still have some of these problems. And if the provider has access to it, they can still do all the things. Plus, search warrants, subpoenas do not protect them. If you have the key, the FBI will say, give us the key. And you'll have to. If it's the same thing in a civil suit.
When you say if you have the key, the cloud provider has to give them the key, or the owner of the data has to give them the key?
Whoever has the key will give them the key. The FBI will order it, or a court will order it, or in a subpoena, a court will order it, you'll have to give it up. You can't say, oh, I don't know, I lost it.
Is there any very nice presentation, number one, any situation where the data is not yours?
I'm sorry, what do you mean?
In other words, can a cloud provider say that the data for some reason isn't yours?
You might agree that it's right. You might sign a negotiated agreement that says you agree that that you're giving us ownership of data and you're now licensing it back, for instance.
They're different. Data it's just not one big bucket where you say, wow, that's data. You can have, okay, so here's our data, which is actually records that we hold in a database table, but then there's data about that data. So metadata, which would be network traffic analysis, things like that. That's a gray area. Who owns that? So that like your data, the stuff that you create, you put up there, that's most likely yours. But then this other stuff around it probably belongs to the service provider.
But they may. When you say submit something to a magazine, sometimes they'll take ownership of the data, and you have a license to reprint it or something.
Right.
Like that.
But for example, if I do a Google search and I did 10,000 Google searches over the last 3 years, one could say that data, those searches, are my data.
Which data?
The actual search itself.
You mean the data about the search or the results of the search?
The actual string text string
Okay.
into a search. I could say it's my data.
Okay, you could say that.
So my question is, Google would probably say, no, it ain't.
Right.
We're giving you a service for basically free.
Right.
So in those cases, who really owns that data?
That is probably owned by Google, but
I'm sorry?
that's probably owned by Google. But there are harder cases. I mean, the harder cases are when you give them your data and say, and they use it in software as a service. There's a lot going on. It's the transactions that they're creating, and who owns the transaction logs, because they may want, if it's e-commerce, for instance, they may want to figure out who's buying what. So it depends on what you agree to. With the jacket and then the.
Yeah, I had a question about one of the companies you seem to be picking on some was Google, and since we're in Washington, D.C., Google seems to be putting on a push to get federal agencies like you were talking about for Los Angeles. And were any of those terms disclosed? I mean, is any of that public information that is, and do you have any comments about that agreement with Los Angeles and Google about specifically about what you discussed?
Right. It's not. I was at a party, I think a Christmas party at my friend and client Sean's house. I have a Plurality Center right there, and I was talking to the CISO for a big government agency, who has a lot of data you probably don't want out, and he was saying that the head of the agency wanted to put their data on Google Docs, and the lawyers were flipping out, and so he just stopped talking to the lawyers. LA probably negotiated a good deal. The actual terms were in public. They talked about it in the news. They said they have full transparency. They said they get to do audits. They have supposedly their own, what you might think of as a private cloud. It's hard to say what really is a private cloud. And it's different for government entities because they're subject to, for instance, federal government's subject to FOIA. There are similar state requirements. I'm sorry, the Freedom of Information Act. It's for private companies where these things, the government's not likely to seize government data. And when they get sued, they usually have to give it up anyway. And you don't really want your government destroying data unless it's sensitive. So for government agencies, the real concern is that it may get out, the sort of security threats that we normally talk about. For private companies who can make these deals, you have all these problems, and it's a trade-off. Much of business is a trade-off, and you decide whether it's a good business decision, whether it saves you enough money to put all this stuff at risk. Random. No, behind you.
So a lot of the questions you raised seem to be similar questions to folks that have been dealing with outsourcing and virtualization providers and providers for a long time. I'm sure you answer this question a lot. What do you see as the sort of specific increased risk to the cloud provider versus the same kind of provider issues we've been dealing with for a long time?
Sure. There are a few things. The first is that there's sort of a rush to do this, and companies really aren't stopping to figure out the way they would with regular third parties outsourcing what deals they're making. They're actually going to Google Docs, and they're just not investigating what these problems are. The other thing is that it's getting bigger. right? There were always these, you have a third party here, you have a third party here. But when all of your stuff is out in the cloud and all of everybody else's stuff is out in the cloud, for one thing, it's not fun anymore, right, to attack a company if you can just attack a cloud provider and get everything. So it becomes an increased threat because there's more of it and because people are leaping without investigating. Plus, cloud providers sort of popping up and everybody wants to do cloud, right? We do cloud. It's like, it's not even cloud, right? It's like iTunes or something. And you don't know who's running them, and it's not your old standard, we have a business interest in keeping this going. It may be these startup companies, and you can't tell how big they are, right? Because it's just available, it's scalable, until it isn't.
So things like that classic, like folks understand the issue of outsourcing providers, but there's sort of general lack of understanding.
Right, and a lot of the providers are either new or doing new things that are sort of untested, and they're trying to do them very quickly.
Isn't that true for most IT things, where the kind of the legal thing trails the actual technology?
Right, although some of this trails by a lot. I mean, the Stored Communications Act, basically, it talks about data as if everything was frozen in the 80s, right? Only data in transit, only data at rest. And so these things, it's not like, we're just a little bit ahead, right? They don't even bother. And some things just will never catch up, right? This problem with seizure of data. What are you going to do, right? Microsoft proposed recently, about 2 weeks ago, I want to say, a new law just to cover cloud computing. So you may see these things as, lawmakers run for re-election, but it's not just that the laws are trailing. It's that the system just, isn't designed for this, and people don't tend to think about it, and when they do, they'd rather not.
Do you know of any notable cases that have been actually cloud computing cases that have actually been negative?
Well,
If you could paraphrase the question too, again, for the internet.
sure, sorry. Do I know of any cloud computing cases? You're not going to see really, unless there's something involving a cloud provider directly, cloud computing cases per se. You're going to see e-discovery cases where the stuff is stored in the cloud. And it'll be hard to tell, what happened. Now, there have been, in discovery, it's not easy. Oh, yeah, you provide this and we provide this and we're all happy. There are big fights. And there are sometimes orders, or at least requests for orders, that companies turn over a hard drive because they haven't turned over the data they're supposed to. When you get a subpoena, what you do is you search through, your lawyers search through, really. And you pay them a lot of money to read everything, make sure it's something you can disclose, and then they send it out. But if you screw around, judge may order you to give up your hard drive or an image or something like that.
You talked about different privacy laws and international privacy laws and state privacy laws. Is there a resource that provides a good mapping for companies for guidance, especially on the international side and the state?
There are, so the question was, is there a good way to find out what all the different laws are? Ask a lawyer. There are some on the web. You can find some tables of state laws, but they tend not to be updated. So they're a little bit behind. They also don't tell you exactly what you need. They'll sometimes point you to the statute, then you got to figure out what you do if there's a breach. And so depending on what you're doing, it's a research project. You have to figure out which laws are going to apply to you and how and what you have to do. So I don't know of any, books you can sort of buy or websites you can go to. Yep.
In regards to the earlier we were talking about privileged conversations between attorney and client and the requirement for a reasonable amount of protection on the end of the client. Do you know of any precedents one way or the other regarding usage of a cloud information service like Gmail? And has that been either shown or not shown to be a reasonable method of protection to maintain client privilege?
So the question is about attorney-client privilege and whether there are cases about whether using the cloud or Gmail or anything like that remains protected. There are cases about Gmail. They tend, and other email providers like that, they tend to talk about whether your employer can look at your email that you use from work. So they don't really relate directly to the cloud, even though it's not at all private, right? It's like, it's a postcard written in pencil, but for some reason it's thought of as private. But for cloud providers, it's very new, and it'll really be fact dependent, right? What did they do? Maybe they did nothing. There was sort of related, it's the same idea. There was a case in Iraq when the Iraqi Provisional Authority was in charge, this sort of pseudo-governmental thing, and there was a company called Custer Battles, which is a great name for a company, especially because it was started by two guys, one named Custer and one named Battles. And they were supposed to provide security. One of the things that involved was bomb-sniffing dogs in Iraq. And they just provided regular dogs. They just sit there, and they wouldn't sniff anything. And that sort of thing, the U.S. government went after them and lost because they weren't actually providing service to the U.S. government. But it went pretty high to the appellate court, and that was if it were that sort of thing where you just had regular dogs, right? That seems objectively unreasonable. After that, it's a gray area. If you leave your notes sitting on a table at Starbucks, not reasonable. If you put them behind a crappy lock in your office, probably reasonable. Hard to know. Other questions? Yep.
Actually, the issue of emails in a company environment, who owns the client corporate email? But is it the owner of the company?
In this country, it tends to be the company.
So even if you get a private email,
I'm sorry?
even if you get a private email to your corporate email account, the owner of the firm can basically say, this is my property.
It depends on what their policy is. It's less a question of property because it's data and copied, and more a question of who has a right to look at it.
That's usually not signed at employment.
Oh, sorry. The question was who owns email, by the way, for the kids at home. And there have been recent cases about that, both with the government and with private companies. And it tends to be what the policy is and do they actually follow through on the policy. You.
What if it's private email through Internet Explorer using webmail and it's their personal email, like Yahoo or whatever, and they're using it at work on the work staff, whose property is it?
So the question was whose property, although I think, again, that's not exactly the right question, is email, personal email like Gmail that you access over the web at work. You own it, but the question is who gets to look at it. Part of it is a question of what the employer's policy is, and part of it isn't. And there are cases being litigated now. The key, these usually tend to involve employee cases, right, where there's employees suing the employer for discrimination or something like that. They tend to be private, but again, it depends. If you're doing it unencrypted and your company says that they watch all traffic, then it seems like they have a right to look at it, but we don't know.
So you kind of talked about the companies set the rules, they set the terms and conditions. The cloud provider says you have these rights, these are revoked, whatever. So what? What's driving them other than corporate reputation to improve their handling and privacy systems? The control of the data, the safety of the data. Is there enough penalties out there from a federal standpoint for these type of breaches to even make them better at what they do, to think about the client's privileges and rights beyond what they do today?
So the question is what's going to drive these private companies to do better? Are there federal or state laws that will punish them? Some of it will be the marketplace, right? They'll have to compete. Some will be they'll get sued for doing really stupid things. That will be fun to watch, unless it's your data. And then you're going to, just like everything, you're going to have, think of Toyota, right? Toyota with this big company, it's got this great name, cars that are known as reliable, and they don't stop all of a sudden. And now GM is running commercials saying, our trucks stop. There are going to be mistakes, but I think it's going to get better. As I said, some things you can't fix. But I think some of these are going to get better. The agreements will get better, although not for consumer things. I think Google Docs will, for as long as we care about, still not warrant anything the way they do with Gmail and everything else. But for businesses, these will be negotiated agreements. The lawyers will sit down and they'll hammer out what the important things are, notice and that sort of thing, just like you do for everything else. When I negotiate agreements between companies, we ask for these things, especially for kind of confidential information, right? If there's a subpoena, we want to know about it so we can contest it, and that sort of thing.
So you mentioned stuff that's being litigated at the moment. What's the best way to kind of keep up to date with changes in legal rulings and things like that from an IT security perspective?
Same place you keep up with any tech news. I mean, it's these things are on Slashdot. EFF does great updates. Follow them on Twitter. Follow me on Twitter as I retweet EFF's tweets. And a little bit of original content. Those two are pretty good. And I send out newsletters every once in a while about interesting updates. Just email me, I'll add you to my list. Yeah, that's it. Yes?
Have there been any major precedent-setting decisions that came down on the side of privacy of the data owner? Because it seems like that there are a whole bunch of requirements and agreements that limit your rights, and I don't remember seeing anything that the court decision said, no, you can't do that.
Yeah, so the question is, have there been any pro-privacy rulings? There was an interesting one. Can't remember what state it was, but it was a police officer who had a text pager, so it wasn't recently. But these things take a while to litigate, and what used to happen was the police force would pay for the text pager unless it went over, and if it went over the allowed limit, then the police officer would have to pay the extra, and that was sort of the way they worked the policy. But then I think the sergeant or one of the superiors got annoyed at what this guy was. This guy was one officer was constantly over, and so he went to the provider who he paid them, and the police officer would reimburse him, and said, "Hey, give me all of his data of his text pages." I assume everybody in the room knows that these things get saved at the provider level, and they did. They gave it over. And there was disciplinary action against the police officer because he was doing a bunch of sex stuff with his girlfriend over his police pager. And the court ruled that it was private. He had a reasonable expectation of privacy because they had essentially a policy of not looking at these things. And they needed a warrant. But it was an early decision, and who knows what happens next. In the back? Like say what?
Say like a Tor network where it's a decentralized network and the data is spread out. But you do have a contract to have your data provided on this network. Does that make this situation with law enforcement possibly shutting it down any better, or does it make it worse?
So the question is, if your data is essentially in a distributed environment where I assume you mean where it's difficult to tell where it actually resides. Well, I mean, if it's encrypted, so you don't mind that it's on some guy's LimeWire account, I guess it's okay. I don't know how you'd run a business that way. I mean, the real question you're asking is, can you hide it a bunch of different places?
If something like Tor was scaled up to a commercial cloud service,
Right.
would this solve some of the problems with these really centralized cloud services, where if you take out one thing, a bunch of businesses are affected, or if they shut down, a lot of businesses are affected?
Well, if it's a truly distributed network, then yes, that would help. If the police can figure out where they are in a seizure case, then you're still screwed. If it's, I mean, I can see where you're going, which is, it's truly distributed, and it's sort of everywhere. So how do you shut it all down? I don't know that you'll really be able to figure out a way to run a business that way, but possible. Guy in the back.
Yeah, I can answer his question succinctly, which is the magic of Tor is that there's nobody to send a
He just said that the magic of Tor is that there's nobody to send a subpoena to. That's not really true. It's just that there are a lot of people to send subpoena. And, well, maybe you can, maybe you can't, right? I mean, people are being identified by the RIAA a lot, but it's more difficult. I don't know if you can really run a true business that way, but start a business. Contact me. I'll help you. Yeah.
Another note on that, whether your data is published out in the different countries, regulations,
So the question was, what happens if you put your data elsewhere? I can't imagine the big companies are going to start locating these things in like tax havens and these lawless places, but they might. If your data is not within reach, then maybe it's protected. But there are international agreements, and subject to these privacy laws, these international privacy laws. Yeah, that might help. Yes.
So a question about I can't answer part of his question regarding your data being out of country. Sometimes if you're law enforcement and you ask nice enough, they'll just give you the information because there's nothing governing them.
Right. He basically said that the guy in the back just said that sometimes if you're in law enforcement, you just ask nicely, they'll give it to you. And that does happen in a lot of investigations. In Foreign Corrupt Practices Act investigations, which are basically foreign bribery, there's a lot of these agencies working together. They just ask and they share. But if it's data that's protected, it's a different story. They're sharing investigative data. If you want to get it from a provider, there was just a news story this morning that in the EU they're ending a system by which the U.S. was able to access data automatically in Europe because they think the U.S. doesn't have good enough privacy protections, which is basically right. Yes?
Is there any laws that recognize the difference between data at rest and data in transit?
Are there any laws that recognize the difference between data at rest and data in transit? Yes, they do. And there are different requirements for them. Yep.
Microsoft has a UL, their end user agreement that basically says that it's sold as is and with all its errors and with all its bugs.
Mm-hmm.
And the cloud computing provider basically say the same.
Yes, and that's what they do. The question is, can they just say it's provided as is and we have no responsibility? And the answer is yes, that's exactly what they do. And that seems like a good time to end. Thank you very much.
Stay right where you are. Tell us when the crypto are next.
All yours.